You're listening to Talking Property on 2UE. Thanks to Fraser's Property. The difference is real. Go to frasersproperty.com.au.
Time to get some legal advice now on Talking Property with the founder of iShack's Conveyancing, Peter iShack. Thanks for joining us, Peter.
Thank you, guys. Good evening, gentlemen.
Now, a number of issues we want to get through. Firstly, let's talk about the security of deposit. Peter Escher was talking to me a little earlier about, investment prospects around Sydney, still very strong, and still, of course, the lending conditions are very favourable. But how do you make sure your deposit's secure?
I think that's been a very, very important topic, particularly when buying brand new and buying properties that are off the plan that are not going to be ready or built for a number of months or perhaps a number of years. And the key component there is to ensure that your deposit sits in either the solicitor's or the real estate agent's trust account. That is really the most important factor. I think the fear around losing deposits is a lot of the times you see on TV where the purchasers buy a property, the property takes 8 or so months to build, and for some reason or other, the developer goes into bankruptcy and then there's a risk of losing the deposit. That risk only arises if you release the deposit to the builder to use it for construction. If your money sits in trust with a solicitor or real estate agent, then that deposit is 100% protected.
Peter, it's great to have you on the program. Another key concern that I wanted to ask you is the variation between buying brand new off the plan and being delivered your product. What's there to protect a potential investor to stop the developer from varying what they've purchased between signing the contract and delivery?
Yeah, very, very good point. And there's been a transition in this over the last few decades. The key component there for a purchaser is particularly what's noted in the contract for sale. And your contract for sale really is the tool with which you tie the developer to comply with what they said they're going to deliver. There's a particular clause in these contracts that is very common with buying a new property and generally common Australia-wide, and that's what we call the 5% variation rule. What that simply states is that the developer is restricted if any variations come about as a result of council requirements or legislation changes. The developer is restricted to minimise those variations to less than 5% of the total size of the property. If that is exceeded, then the purchaser has the right to pull out of the contract to renegotiate the price. That's
very, very important. So just to clarify, if you were to purchase something and it's greater than 5% difference, you have the right to pull out of that contract.
Most definitely. Now, you've got to make sure that condition hasn't been altered. Some developers are cheeky and change that to 10% or 7%.
Yep.
You've got to make sure you look at that very carefully. But yes, that's exactly right.
Okay. How about defects, either large defects or minor defects? I know you've spoken previously about the importance of having a building expert at your pre-settlement inspection. If somebody like that does pick them up, or if you're cluey and you do pick them up yourself, what's there to protect you?
Definitely. There's a very, very important difference between buying a brand new property and a property that's already 5 or 10 years old, and that is the way the law allows you as a purchaser to deal with defects. Defects are distinguished by minor and major, and the difference is very simple. Anything that stops your tenant occupying the premises from a legal or safety perspective is classified as major. And what the law says there is you're entitled to delay the settlement. An expert person inspects the property, identifies what those defects are and gets it rectified, and at such point then you can proceed with settlement. With minor defects, though, as such as hairline cracks or wall scratches or ripped carpets or cement on windows, the law allows you to still get the developer to rectify those defects at their own cost. However, you still have to settle and proceed with the transaction simply because you'll still be able to put a tenant in there and get a rental return.
Bill and I were speaking about timing in brand new projects, and there are a lot of large projects taking place at the moment, particularly along the eastern states, and there is some time delays starting to creep in because builders are busy and the office of the government's registering title and everything else. If there are time delays, Peter, what's there to protect the purchaser for a brand new property when there are delays with completion of the project?
Yeah, a very important point. I guess in this scenario, you've got to look at the intention why you're buying the property. If you're an investor, I myself as an investor, I find time delays at different times very advantageous for the simple reason that I've got an asset that's appreciating in value and it's not costing me any money to hold. However, in saying that, normal with time delays, you need to ensure that there is a sunset clause in the contract that basically restricts the continual delay of a project. And there's been a lot of speculation of a sunset clause, particularly in the last 18 months, where In some instances, these clauses allow either the vendor or the purchaser to pull out of a contract. The whole concept of a sunset clause is to restrict the extended delays of a construction of the property, that once that sunset clause is met, if the developer hasn't complied with its obligation, it allows the purchaser the ability to pull out of that contract. But that sunset clause can be a double-edged sword, so you have to make sure it is very well structured.
For some of our listeners that have never heard of a sunset clause, can you give us an example? Can you illustrate it? What are these sunset clauses?
So let's use a hypothetical. You buy a property that's due to be completed, an apartment, an off-the-plan apartment in the heart of the CBD. It's due to be completed in 12 months. The sunset clause is basically a clause that is put in the contract that allows the developer extended time in order to complete the property. So, for example, that will be a condition in the contract that says the developer has 36 months from the date of the contract to deliver the final product.
So they can't take forever. They can't just sit there and say, you know what?
They cannot keep going forever.
Okay, very important.
And I guess one of the factors in this too, Peter, and it did receive some negative publicity, is some of the lesser scrupulous developers taking the opportunity when the market price has gone up to buy back units and basically extinguish the sale because clearly the market's boomed. I understand that's probably not as likely to happen in the current climate as it was, say, 1 or 2 years ago, but that's also something you need to be wary of, isn't it?
No, most definitely, 100%. I mean, a few, and very interestingly, there have been a few cases in the last 18 or so months where that exactly has happened, particularly in the Sydney market. I mean, the Sydney market has experienced insane growth between 2011 and 2015, and there has been many instances where developers, in fact, succeeded at court in being able to get out of the contract and sell the property for a higher gain, which is obviously completely unfair to the purchaser. But that has now been redefined. The condition has been redefined. It's been structured very well, and a precedent has been set to protect investors that basically developers cannot take advantage of that as they have in the past.
Pete, last question: valuations. What should people do to prepare themselves when it's just there, about to settle, ready to go? What are your legal tips?
Look, most definitely in close communication with your finance provider and broker. When you're about to enter into a new acquisition, particularly if it's a long-term acquisition, you have to understand that, number one, make sure you get the property valued based on today's comparison. That is very, very important. Do not work on a projected valuation that when this property is completed is going to be worth in 2018 or 19, but work on today's valuation. But number two, also understand that valuations are an opinion of an individual working for the financial provider, and they could vary. So when settlement time comes, make sure you have a buffer, and that is simply either cash in the bank just in case there's a shortfall, or equity in another property that you can contribute if the valuer's opinion differs from that which is on the purchase price.
Peter Ishak from Ishak's Conveyancing, very sound advice, whether you're investing, of course, or purchasing your own home. Thank you very much for your time, mate.
Absolute pleasure. Wonderful living there, Bernie.
Thank you.
And don't be afraid of the process. If you have a good conveyancer, I'm sure these things are not as tough as they look. And do people sometimes